All right, thank you. And remind everybody again to turn off your cell phones. Now, ladies and gentlemen, the jury service may be strange to some of you, so a brief explanation is in order. Those who participate in a criminal case must do so according to established rules. That's true of the parties, the lawyers, the judge, and the jury. The lawyers present the evidence according to the law. The judge enforces the rules and decides what evidence may be admitted. Now, I don't do that just on the basis of what I think is fair or right. It's based upon specific rules that I'm given through legislative acts or rules adopted by the Supreme Court that dictate what evidence is properly admitted. And those are the rules that I apply. Now, you will be the sole judges of the facts and the credibility of witnesses and the weight to be given to the testimony that is admitted. And at the conclusion of the evidence, the court will instruct you on the law regarding those matters, and you'll apply that law to the facts. It is your sworn duty as jurors to accept the law as it is given to you by the court, regardless of what your opinion is of what the law is or should be. Now, the procedure for the trial will be as follows. First, the attorneys will outline what they expect the evidence will be. Now, these opening statements are not evidence. They are simply a preview or outline, if you will, of the claims of each party, what they believe the evidence will be. They're designed to help you follow the evidence as presented. Now, after that, the state of Ohio will offer its evidence. Upon conclusion of the state's case, a defendant may, but is not required, to offer evidence. If the defendant does present evidence, then the state may, but is not required to present what's called rebuttal evidence, simply to rebut things that were discussed during the presentation of the defendant's case. After that, the court will instruct you on the law. There will be closing arguments, and then I'll instruct you on the deliberations. And after that, you will deliberate and return your verdict. Now, questioning of witnesses will be as follows. The party that calls a witness will ask questions first. That's called direct examination. After the completion of that examination, then the opposing party may ask questions. That's called cross-examination. Then, upon completion of the cross-examination, the party that called the witness originally may, it's not required to, but may ask questions regarding matters that were raised on the cross-examination only, and that is called redirect examination. Now, jurors, in case I have this come up occasionally, jurors are not permitted to ask questions. Now, during the trial, it's likely an attorney will make an objection. This is the means by which an attorney raises a point of law that must be decided by the judge. And then I will issue a ruling. Now, if an attorney objects to a question and I determine that the question and or the answer, the expected answer, are not permitted, then I'll say sustained. And that means it's not going to be answered or admitted. If I say overruled, that means I've determined that the question and the likely answer are permissible under the rules and may come into evidence. Now, sometimes when people in a trial, people talk, simultaneously, the attorney and the witness, or a witness may answer something very quickly before the other party has the right to, or has an opportunity to make an objection. And so the witness has made an answer. And then after I consider the objection, if I determine that that was not proper under the rules in the law, then you'll be told at the end of the case, or perhaps at the time, that you're to disregard that testimony. Or an attorney may ask the court to strike something from the record, and that means the same thing. When you deliberate, you're not permitted to consider anything that was sustained or stricken, or you were told to disregard. Now, we understand you're not computers where you can just hit delete and it's gone. You may remember that. The way that is applied is that if somebody says, well, remember that was said, if that was something you were told to disregard, or you're not permitted to consider it, and you have to bring that up. Now, it's important that you be fair and attentive during the trial. We anticipate that the evidence will be completed possibly this morning or certainly early afternoon. But there will be a break before the case is unlikely is submitted to you, I'm sure. And so during the breaks, you're not to communicate in any way about the case with anyone. You're not to discuss it with any of the parties, with any people that you might see at lunchtime, or during a break if you're walking around outside. in the courthouse. You're not to discuss the case with anyone. That includes yourselves, among yourselves. You may think, well, why is that? We're on the jury. Well, until everything is presented, all of the evidence is in, and you've heard all the instructions of the law, and you've heard closing arguments, opening statements, everything that's part of a trial, you're not in a situation where you can return a verdict. And so therefore, you're not to have any discussion, even among yourselves, until that time. Now, if you have lunch or talk during the breaks with others, you explain to them that rule, that you're not permitted to discuss it. And I know I had an example of somebody saying that they kept telling their family member that they weren't allowed to discuss it. And they said, well, I served on a jury and I was allowed to talk about it. Well, that is after the case. And people sometimes forget at what point. So once the case is completed and you returned your verdict, then you're free to discuss it if you wish with anyone. You're not required to, but you may. Now, in the event that something comes up that you think, like somebody says something to you, or there's something that comes up during the trial that you think has a bearing on your ability to be a juror, report that to the bailiff, and then the bailiff will report it to me, and I'll consult with the attorneys and then make a determination of what steps are necessary, if any. Now, once in a while, that requires that the court interview the juror to determine exactly what it was that was said and what the juror, what effect that might have on them, if any. And so I have to bring you in the courtroom and ask you that. For that reason, I'm instructing you that if something like that should come up, don't ask any of the other jurors what you think you should do, if they think it's enough that you should report it. And the reason I bring that up is this. About 25, 30 years ago, when I was prosecutor, we had a 5-day trial. And on the third day, we had an incident at lunch where one of the jurors was overheard a witness say something that they hadn't testified yet. And so they reported that, but before they did, they came back to the jury room, and we had 15 jurors, had 3 alternates, and they said, here's what happened. Well, we spent the entire afternoon questioning 15 people. We lost the whole afternoon of trial. So that's why I tell you, don't ask anyone else's advice. Err on the side of report it, and that way it'll just be you. You may tell somebody, well, I have to report something that happened. Just don't tell them don't tell the other jurors what that was. Now, you're instructed to not read, view, or listen to any report in the newspaper, radio, television, or any type of media, internet, or social media on the subject of the trial. I don't know that we'll get any news reports, although since we do broadcast on YouTube now, the media often will monitor that and post it, post a story, but you're not permitted to read any of those things, and not to read anything that might be posted in a media, a social media, if somebody else is watching the trial or somebody's aware of it. And the reason for that is those individuals, they report something they think is interesting or what they think is important, and it may or may not be. But they are not under the obligation that you are to listen to everything, be fair and impartial, and apply the law. And so it would be improper for you to consider that. If you are a person who does post social media of any sort during this time, don't post about the trial. In fact, don't even post at your own jury duty, because again, that might result in one of your friends saying, oh, I'll bet it's blah, blah, blah case, and that person is blah, 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 and then now all of a sudden you've got a problem. So it's just simply better not to post about it. Once the trial's over, if you want to post about your experience, that's fine, you may do so. Now, you're not permitted to take any notes during the trial. This is going to be a fairly short trial, to not very many witnesses. And so and I use my own experience. It may not be everyone's, but since it was mine, I just don't want anyone else to fall in the trap I did. And that was when I was 18 years old, and I was at first class at 8 o'clock in the morning in Ohio State, with like 150 people in the class. And I started writing down everything the professor said. And then about halfway through the class, I realized I wasn't listening. I was too busy writing something I just heard that I wasn't hearing the next 2 or 3 statements. I was missing stuff. So that's why I tell people, I eventually learned, at least I think I did, to multitask and be able to watch and listen and write at the same time. The result was some really crappy handwriting, but I got the stuff in class. So that's why I don't let jurors take notes on short trials. Now, if we have a long trial, a week or so, I do, but we have certain things that are built in to help protect that. But for this trial, there won't be any notes. Now, you've already seen us have the attorneys come up to the bench and have what we call a bench conference, and that may happen during the time. It may be discuss a logistical issue or scheduling issue or something of that nature. Or if there's an objection and the attorneys want to argue the objection, then they come up here and they do that, and then I make a ruling. And the reason we do it that way is that if they did it in front of you and you were listening to all this, and sometimes it might be several minutes, not often, but sometimes, then you would hear all that, and then in the end I said, nope, it doesn't come in, the objection is sustained, then that's a whole bunch of stuff we've got to forget and not use. So just to protect you and lighten that burden on you, we don't let those arguments take place in front of the jury. We do it at the court. Up here, it's in front of you, but you don't hear it. Okay, so, and also during the recess, I'll instruct you to remember the instructions or the cautions or the admonitions of the court. That's all those are descriptions of what I've just told you that you're to observe during those breaks. I don't repeat everything, but I'll instruct you to remember the instructions of the court and comply with those. Okay, now we're going to start the trial. First stage is opening statements, and each of the attorneys on each side have the right to present an opening statement, which again is not evidence, as I instructed you earlier. It is simply their belief as to what the evidence may be during the presentation of that evidence before you. So at this time, we'll start off with the state. Mrs. Collins.
May it please the court, defense counsel, ladies and gentlemen of the jury, today the state will prove beyond a reasonable doubt that this defendant, Allan Shoemaker, violated a protection order by sending a letter to his ex-wife, Teresa Shoemaker. Teresa and Allan were married for about 36 years, but in July of 2019, the final decree of divorce was filed. In June of 2023, Teresa filed for a protection order which would prohibit the defendant from having any sort of contact with her, and the protection order specifically included a prohibition from him sending her mail. That protection order was granted, and the defendant was served with a copy of that order on July 7th of 23. In September of 23, the defendant was at the Highland County Justice Center. Now, the jail there keeps logs of all mail that inmates send out. On September 24th of 23, this defendant sent a letter to Teresa Shoemaker. Teresa received that letter at her home on September 27th of 2023. It immediately took the letter to the Highland County Sheriff's Office to make a report of the violation of the protection order that was in place. Again, a protection order that specifically prohibits him from sending her mail. Today, Teresa will explain how she filed for and received a protection order prohibiting the defendant from any contact with her. You will see a certified copy of the protection order, the letter and the envelope, and a copy of the jail mail log. Lieutenant Keith Brown of the jail will explain how they keep detailed notes of the outgoing mail from the inmates. Finally, you will hear from Deputy Ronnie Hughes of the Sheriff's Office, who took the report from Teresa, gathered the necessary documents to prove this charge, as well as certified copies of a prior conviction, making this charge a felony. After you hear the testimony and review the evidence, I am confident you will find this defendant guilty of violating the protection order that was in place when he sent a letter to Teresa Shoemaker. Thank you.
All right. On behalf of the defense, Mr. Kirk.
Good morning. May it please the court, ladies and gentlemen of the jury in the state of Ohio. Ladies and gentlemen of the jury, this case boils down to whether or not Allan Shoemaker violated protection order by having contact via mail with Teresa Shoemaker, his ex-wife. You heard that they were married a very long time, and you will hear evidence that there was a civil protection order. Mr. Shoemaker does not deny that. You will hear evidence that he did send a letter on September 24, 2023. He doesn't deny that. It's who the letter was sent to that it boils down to. In this particular case, you will hear testimony or evidence about the fact that the parties had 3 adult children together, and that Mr. Shoemaker has a nickname for one of those children named Grace. You will see on the exhibit that we expect the state will introduce, which will include an envelope with the name Grace on the outside, Grace Shoemaker. You'll see Teresa's name, but then attention, Grace Shoemaker. So we ask that you really focus on that, because the intended recipient, as the evidence will show, was in fact Grace Shoemaker, not Teresa. You will also hear evidence that Mr. Shoemaker was in jail at the time. He did send that out. and that the jail screens mail before it goes out, and this one was allowed to proceed and was in fact mailed. You will notice on the mail itself, inside, if you look carefully at that, you will not see Dear Teresa or anything to do with Teresa on the contents as well. So we just ask that you focus in on those things as you're considering the case, because we think those are very important things to note. You will notice that the contents of the letter make no threats, and we're not here about a case where somebody called somebody to violate the order or showed up at their home. It boils down to this letter that was sent, and we would argue to Grace Shoemaker rather than Teresa. On behalf of Mr. Shoemaker, I want to thank you all for this is one of the few times we get to talk to you like this, and I want to thank you all for your service today. As Judge Coss noted, this is one of the best justice systems in the world, and that's because we have people who do show up for jury duty and do participate and are attentive and listen. And so we just want to thank you for that. And we would ask that after considering all the evidence and keeping an open mind, that you would return a verdict of not guilty. Thank you.
All right, thank you. First witness?
Teresa Shoemaker.
Okay. Have you been sworn in the clerk's office? All right, if you would go right over there and have a seat, please. And there's a microphone there. If you would slide that clear over to your left, please. All right, you may inquire.
Please state your name for the record.
Teresa Ann Shoemaker.
And can you spell your first and last name?
Teresashoemaker.
And Teresa, do you know Allan Shoemaker?
Yes, I do.
And how do you know Allan?
We were married for 36 years.
Now, at some point, did you file for divorce from Allan?
Yes.
And when was that divorce finalized?
June 19th, April 2019.
In 2019?
19, yes,
Okay.
sorry.
And do you see Allan Shoemaker in the courtroom today?
Yes, I do.
Could you please point him out for the court? Please let the record reflect the witnesses identify the defendant.
It's ordered.
Now, during the time that you were married to the defendant, did you see his writing?
Yes, I
on the
did.
road? Can you identify his writing? Did you see it?
Yes, I can.
Did you file for a civil protection order against the defendant in 2023?
Yes, I did.
And why was that?
Correspondence that I had received from him indicated that he does not accept the divorce, and some of the content was viewed as threatening.
May I approach the witness?
You may.
I'm going to hand you what's previously been marked as State's Exhibit 2 for identification purposes. Do you recognize that?
Yes, I do.
And what is that?
That's where I was granted the protection order after filing.
On September 27th of 23, did you receive mail at your home?
Yes, I did.
And what's the address of your home?
4328 Newman Road, Hillsborough, Ohio.
I'm going to hand you what's previously been marked as State's Exhibit 1 for identification purposes. Do you recognize that?
Yes, I do.
And what is that?
This is the letter that I received.
Is that the envelope attached to it that you received the letter in?
Yes,
And were you able to recognize the writing in that letter?
yes.
Whose writing is it?
This is Allan's writing.
What is the return name and address on the letter?
Allan Shoemaker, 130 Homestead Avenue, Hillsborough, Ohio.
Now, have you received mail in the care of someone else from the defendant before?
Yes.
And who were those letters addressed to?
There was Courtney Rhodes, Seth Shoemaker, Ethan Shoemaker, and Grace Shoemaker.
Now, who is Seth, Courtney, and Ethan?
Those are our children.
Who is Grace?
I don't know.
Does Seth, Courtney, or Ethan live with you?
No.
When you've received mail in their care previously, have you provided that mail to them?
Yes.
And again, do you know Grace Shoemaker?
I don't.
Does a Grace Shoemaker live with you?
No.
Have you ever heard this defendant call Courtney Grace Shoemaker?
No.
Did Does she go by that nickname? Does Courtney go by a nickname of Grace?
No,
Is that her middle name?
no.
After you received this letter, what did you do with it?
I took it out to the sheriff's department and filed a report.
And no further questions?
You done?
Yes.
Cross.
Good morning, Ms. Shoemaker. I heard you testify that that your children have received mail at your address. Is that true?
Yes.
And when was that?
Oh, it's been periodic over the years.
Okay.
I don't have exact dates.
So you'd say it's been consistently throughout the years?
Yes,
And you acknowledge that the letter written we're talking about this morning said attention Grace Shoemaker on it, correct?
yes,
And there has been previous letters written that said to Grace Shoemaker, correct?
yes.
Was there any threats in this letter?
Objection, relevance.
What was the question? Christmas?
Was there any threats in this letter?
Was there any what?
Threats?
No, I'll sustain that.
Was there any threats in this letter?
Your Honor, objection.
I sustain the
Sorry,
objection. You
I'm
may
sorry,
not ask
I'm
that
sorry.
question.
Included in the letter, was there a cover page?
I don't believe so. I think it was just straight letter.
Okay, but you can't say for sure?
I can't remember what was in that letter.
Okay. And did you open the letter?
Yes,
Okay. And why did you open it if it was attention Grace?
because I do not know of a Grace, and just wanted to see what the content was.
Okay. No other questions?
Redirect?
Thank you. When when the defendant has sent mail to your home in the past in care of other people, did he specifically send letters in care of Courtney?
Yes,
So if he wanted the letter to go to Courtney, he used the name Courtney.
yes,
I'm going to, again, present to you State's Exhibit 1. Is this the entirety of everything that was sent to you? Is that everything that was sent?
yes,
That's the whole thing?
this is it.
Okay. No further questions.
All right, you may step down. Next witness?
Keith Brown?
Were you sworn in the clerk's office? Yes. All right, just have a seat over there. Turn your cell phones off. May inquire.
Please state your name for the record.
Keith Brown.
Are you currently employed?
Yes, I am.
And where are you employed?
Highland County Sheriff's Office.
How long have you been employed in law enforcement?
Almost 30 years now.
What are your job duties at the sheriff's office?
I'm one of the jail administrators and run the jail on daily operation.
Have you become familiar with Allan Shoemaker?
Yes, I have.
And do you see Allan in the courtroom today?
Yes, I do. Right over there.
Please let the record reflect the witnesses identified the defendant.
So order.
On September 24th, was the defendant incarcerated at the Highland County Justice Center?
Yes, he was.
Do you have a process at the jail of keeping track of mail that comes in and out of the jail for inmates?
Yes, we do.
And can you explain the process?
It's actually one of the state standards we have with for the jail inspection. You log all incoming and outgoing mail, name and recipients of both sides.
May I approach the witness?
May.
I'm going to hand you what's previously been marked as State's Exhibit 3 for identification purposes. Do you recognize that?
Yes, copy of our jail inmate log.
And from what time period?
It'd be from, looks like September of 23 clear to October of 23.
And is that a form that is completed and kept in the ordinary course of business in the Highland County Jail?
Yes, it is.
Referring to the top line of that jail mail log, who is the inmate that logged mail to send on September 24th of 23?
Allan Shoemaker.
And who is the recipient of that mail?
Teresa Shoemaker.
No further questions.
Cross.
No questions, Your Honor.
All right, you may step down. Next witness.
Deputy Ronnie Hughes.
Have you been sworn in? All right, you may inquire.
Please state your name for the record.
Ronnie Hughes.
And are you currently employed?
I am.
Where are you employed?
Highland County Sheriff's Office,
And how long have you been employed there at their sheriff's office?
24 years.
What are your job duties at the sheriff's office?
Answering calls of service, traffic investigations, traffic enforcement, and investigating crimes.
Were you so employed on September 28th of 23?
I was.
And did you meet with Teresa Shoemaker that day?
I did.
And what was the nature, just generically, the nature of her report to you?
She brought a letter that she had received from her ex-husband to the office, which was, in her opinion, was a violation of a protection order.
Were you able to locate Allan Shoemaker?
Yes.
Where was he?
He was in the Highland County Jail.
Do you see Allan in the courtroom today?
I do.
Can you please point him out for the court?
He's seated right there.
Please let the record reflect that witnesses identified the defendant.
Sword.
And were you able to ascertain Allan's date of birth?
October 14th of 1958.
I'm going to hand you what's previously been marked as State's Exhibit 1 for identification purposes. Do you recognize this?
I do.
And what is that?
This is the letter that Teresa had brought to the sheriff's office.
Is that also the envelope that was with the letter?
Yes.
And what is the return name and address on that letter?
It's Allan Shoemaker, and the address is 130 Homestead Avenue, which is the Highland County Jail.
And is that, what county is that in?
That's Highland.
And what is the address that the letter was sent to?
It says 4528 Newman Road, but I believe it's 4328 Newman Road.
Is that in Highland County also?
It is.
And did Teresa advise you that the defendant was under no contact order?
Yes.
Were you able to confirm that no contact order?
Yes.
I'm going to hand you what's previously been marked as State's Exhibit 2 for identification purposes. Do you recognize this?
Yes.
And what is that?
This is a certified copy of the protection order that was issued.
And who is the protection order against?
Allan Shoemaker.
And is the date of birth on the protection order the same as the one you were able to ascertain for Allan Shoemaker?
Yes.
I'm going to direct you to page 6 of 7 of that order.
Well, I know it's here somewhere. There we go.
Line 26. Is that box check marked?
It is.
And what is written there?
It says, "It is further ordered, Allan Shoemaker shall have absolutely no contact with Teresa Shoemaker, comma, even by mail."
I'm next going to hand you what's previously been marked as State's Exhibit 4 for identification purposes. Do you recognize that?
Yes.
And what is that?
This is where the protection order,
Is the bottom of it the return of service where it was served?
yes,
And is that a certified copy of the service?
yes,
And was that served by a deputy sheriff of Madison County?
I believe it was, yes.
Okay. Now, according to the return of service, when was it served on the defendant?
July 7th of last year.
And were you also able to ascertain if the defendant had previously been convicted of violating a protection order?
Yes,
I'm going to hand you what's previously been marked as State's Exhibit 5 for identification purposes. Do you recognize this?
yes.
And what is that?
This is a certified copy of a conviction through
It is-
municipal court.
And is that conviction violating a protection order?
Yes,
And I'm sorry, I interrupted you, but what court was that from?
Hillsborough Municipal Court.
And is that for Allan Shoemaker?
Yes.
And no further questions.
Ross?
When you conducted the investigation, did you attempt to be very thorough, correct?
Yes.
And speak to all parties involved?
I didn't speak to Allan Shoemaker.
Okay, and why not?
Objection.
Sustained.
Did you speak to, who else did you speak to?
I spoke with Teresa.
So during this investigation, you only spoke with Teresa?
Yes.
No other questions?
Redirect.
None, Your Honor.
All right, you may step down. The next witness.
No further witnesses.
All right, state's resting.
Yes, Your Honor, after admission of our exhibits.
All right. Ladies and gentlemen, we're going to take, I ask you to step into the jury room because I have to deal with some legal matters regarding the exhibits. And then once I do, we'll have you brought back in, so it should only take a few minutes. If you would go to the jury room, please. Again, during the jury, while you're back there, don't use your cell phones or talk about the case in any way.
Please rise.
Okay.
I have one more, Judge. You can see him.
All right, now there's a motion to admit the exhibits 1 through 5. Are there any objections to that?
No, Your Honor.
All right, they'll all be admitted. You wish to make a Rule 29?
Yes, Your Honor.
You wish to argue?
Your Honor, we would make the Rule 29 on the basis that the state has not met the burden of beyond a reasonable doubt in this case. The letter was addressed to Grace Shoemaker. The key witness, which is Teresa Shoemaker, even acknowledged that there's been prior mail to Grace Shoemaker. She acknowledged that even though it was addressed to Grace Shoemaker, she chose to open it. So based upon the evidence presented, would ask for the court to, under Rule 29.
Ms. Collins?
Your Honor, the letter is addressed to Teresa Shoemaker. Grace's name is at the bottom of the letter, and there is no Grace Shoemaker. She opened it because there's no Grace Shoemaker. The person does not exist. I believe that it's addressed to Grace Shoemaker as a ploy so that he could later argue that he wasn't trying to have contact with his wife, whose name is one that right on the front of the mail or the envelope, front and center in the middle, and it was sent to her address. I think that the jurors definitely could come to differing conclusions on this, and as such, we would ask that the Rule 29 motion be overruled. Thank you.
Mr. Kirk, can you respond?
And nothing further, Your Honor.
Where is Grace Shoemaker? The one I'm looking at, the envelope says Teresa Shoemaker.
Look at the bottom, Judge.
Bottom of what?
Hit the address.
Oh, attention, Grace Shoemaker. Okay, I got you. All right. Well, the evidence is that there is no such person as Grace Shoemaker. It's clear that it was addressed to the defendant. Even if it were addressed to was for another person, the order says that he's not to have any contact with Ms. Shoemaker in any way. So that doesn't mean that he can mail things to her to give to others, even his own children. So based on that, the court finds that's evidence is sufficient that the jury could reasonably determine that he is guilty by proof beyond a reasonable doubt, although that is their decision. All right. So the motion is overruled. Now, is the defense going to present any evidence? Do you wish to have a few minutes?
We will be calling our client to testify.
All right. Do you need a few minutes to go break?
If we could, yes.
All right, we'll take about 5, let's see, it's 10:27, 10:35. Be back at 10:35.
Please rise.
All right, so we're back on the record now. Is defense going to present witnesses?
With just our client.
All right. Now, Mr. Shoemaker, before you testify, I don't want to do this in front of the jury. I want to put it on the record that if you testify, anything you say, the jury can use against you or for you, depending upon how they view it. Now, one thing that your testifying will do is, right now, the only thing that's in the record is your one conviction in municipal court for the violation of protection order. Under the law, if you testify, any felony convictions that you have that are within 10 years since your discharge, and I think there's 2 or 3, you can be asked that by the state for the purpose of impeaching your testimony, and the jury could consider that in evaluating your credibility only, not as to whether you committed the crime, but for purposes of credibility only. You understand that?
Yes,
All right, and with that understanding, it's your decision to testify.
yes.
All right, now you bring in the jury, please. Be seated, please. All right, ladies and gentlemen, took a little bit longer than I thought to deal with those matters, but now we are prepared to go forward. The state has rested the exhibits, 5 exhibits that were testified to have been admitted by the court, and it's now the defense's turn to present evidence. First witness for the defense.
Be Allan Shoemaker.
All right, Mr. Shoemaker, if you come up here, please. Would you raise your right hand to be sworn, please? I'll do that. Yeah. Do you solemnly swear that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, have a seat right there. And pull that microphone over in front of you, please. All right, you may inquire.
Sir, would you please state your name for the record?
Allan Wayne Shoemaker.
I understand you may have some hearing loss in here, so if you have trouble hearing me, just let me know, okay?
Okay. If I turn my head, that's trying to get to where I can hear you better.
Okay, just let me know if you cannot, okay? Were you previously convicted of any felony offenses in the past?
Objection.
Sustained.
Did you, in this case, you were married to Teresa Shoemaker, correct?
Yes.
And did you and Teresa, how long were you married?
36 years.
And did you have any children together?
Yes.
And how many children?
Well, there's 3, yes.
Okay, you hesitated there. Was there a 4th or something?
There was a miscarriage.
Okay. And the 3 children that you have together, are they adults now?
Yes.
And what are their names?
There's the ones now is Courtney, Seth, and Ethan.
And there was testimony that some letters had been received at Teresa's address before for those children. Were they from you, those letters?
The one sent to the kids, yes.
And so was it common to send letters to your children at Teresa's address?
I didn't have any other address to send it to, so I just figured if I could get it in that direction that she could hand it off.
Now, in this case, there's been discussion of a letter that was sent from the jail on September 24th, 2023 by you. Do you recall that letter?
Yes.
And who did you send that letter? Who did you send that letter to?
It was sent to Grace.
And who is Grace?
That would be my daughter. That was a nickname that I'd given my daughter.
And which daughter?
Her legal name is Courtney.
So that's a nickname for your daughter, Courtney?
Yes.
Okay. And is that did Courtney have several nicknames?
She had a couple others, yes.
And that's one particular nickname that you used?
That was the nickname, that was the name that I give her, yes.
Now, why send Courtney mail in the name of Grace?
It, it was just the name I thought of at the time,
And why send it to Teresa's address?
because I had no other way of getting it to her.
And the exhibit, you heard testimony about that exhibit, correct? About the letter?
Run that past me again.
You heard testimony about the letter earlier, correct?
Yes,
Is it your understanding there could be something missing from the letter?
there was a sheet, cover sheet, that basically what it stated on there.
Objection, hearsay.
I'm going to sustain that.
So when you sent the letter, though, there was an additional page?
Yes,
And was it addressed to Teresa?
no, her name is not on it.
Whose name was on it, if any?
Grace.
And that, to your understanding, that is not part of the exhibit that the state presented?
That's not what I've seen. From everything that I've seen, it's not there.
Okay. My approach?
You may.
This is the,
Yeah.
I'm going to hand you what state has been previously been marked as state's exhibit number 1. Can you take a look at that? Is that the letter you wrote?
That's the letter I wrote, yes.
And what's it say on the envelope as far as who you wrote it to?
It's written, it's sent out to the Newman Road address, but it's to the attention of Grace Shoemaker.
And is there, when you look at that letter, anything missing?
That would be the first sheet.
And
That
sheet's
would,
not there.
that first sheet's not there.
And was this letter any attempt to contact Teresa at all?
No.
And were you aware you could have no contact with Teresa?
Yes, sir, I did.
And in this case, did you have in mind that Teresa might get a hold of this letter?
I'm not, no, I can say no.
And again, who was the intended recipient?
The intended recipient was my daughter Grace.
And that's also known as who?
Courtney.
No further questions.
Ross.
Mr. Shoemaker, how many prior felony convictions in the past 10 years
I think
do you
there
have?
How many counts?
How many, yes, how many prior felony
There's
convictions?
4.
Are you sure that's not 5?
Excuse me?
Are you sure that's not 5? Would 5 be correct?
Could be, I don't know.
A breaking and entering in 2019,
I plead guilty to that, yes.
and that was menacing by stalking in 2019,
Yes,
violating a protection order in 2019,
yes,
failure to appear in 2019,
yes,
violating a protection order in 2020.
yes.
And who is the victim of those violating a protection orders? Were they all Teresa
That would be Teresa, yes,
in every one of those cases?
yes.
And may I approach?
You may.
And you admit that you are the person that was convicted of violating a protection order in the Hillsborough Municipal Court?
Yes,
And again, the victim was Teresa?
yes,
So you admit that you knew you were to have absolutely no contact with Teresa?
yes,
And you knew that included no contact by mail?
yes.
Now, you claim today that Grace is Courtney's nickname. However, no one else knows this nickname except for you, isn't that correct?
As far as, yeah, but she had several nicknames.
You knew that you were not allowed to send mail of any kind to Teresa, isn't that correct?
I knew I wasn't allowed to send it to Teresa.
And whose name is on the top of that envelope?
It's addressed to her address in care of,
Whose name is that?
it's Teresa,
Teresa Shoemaker.
yes,
And you knew you were not allowed to have it send any mail to Teresa, correct?
I knew I wasn't allowed to send any mail directly to her
Okay. And that's her name?
with my daughter's name underneath.
No.
Grace is not your daughter. Courtney is your daughter, isn't that correct?
No, Grace is my nickname for my daughter.
This is Teresa's name, correct?
Yes.
So the mail was sent to Teresa.
And you've already testified that you were the only one that knew about this nickname.
I'm sorry. Try again.
I have no further questions.
Redirect.
No further questions.
All right, you may step down, Mr. Shoemaker. All right, are there any further witnesses?
No further witnesses. We would rest.
You wish to present any rebuttal?
No, Your Honor.
All right. Well, ladies and gentlemen, I hate to do this again, but we're going to send you back to the jury room because I have some more legal matters I need to address out of your presence. So if you would go back to the jury room, and this time it shouldn't be quite as long. Counsel, would you approach? I just had trouble finding one that was in backwards, so we're good. Here are copies of the revised jury instructions. Hand that out, please. Oh, sorry. All right. You wish to renew your Rule 29?
Thanks.
Yes, Your Honor.
All right. Court will deny that. Reasonable minds could come to different conclusions. The evidence is sufficient that the jury decided to find the defendant guilty, be supported by sufficient evidence. All right. So we're going to go ahead and I'm going to go ahead and instruct the jury here, and then I think we'll do closing arguments, and then I'll probably send them to lunch and then bring them back and do the final instructions on the verdict forms. Now, before we do that, I want to go over the revised jury instructions. We did go, this represents the changes that were made from our discussions this morning in chambers. And on page 2, I'll unhighlight the testimony of the defendant to be weighed by the same rules. And then on page 3, the evidence, or that last part of the last sentence and first paragraph is highlighted, and I'll unhighlight it, already have, and unbold it. And I also am going to add additional instruction, and that is that there was testimony that he was in jail at the time and sent the letter from jail. So I'm going to indicate it that the testimony has been received, that the defendant was in jail when he sent this letter. You're not to consider the fact he was in jail for any purpose. I'm going to add that. I assume there's no objection from the defense.
No objection.
And if the state objects, you won't.
Fine.
Okay. All right. Now, I believe then all the other changes that we discussed have been made, and the verdict form as well. Are there any additional requests for, let me rephrase that, any requests for additional instructions beyond that are in the document that's prepared? Anything from the state?
No, Your Honor.
Defense?
No, Your Honor.
Okay. All right. And are there any objections to the as prepared?
No, Your Honor.
From the state?
No, Your Honor.
All right. Okay, anything else before I bring the jury back in?
No, Your Honor.
All right. Then bring the jury in, please. Is the jury room still pretty warm? Okay, I was going to say, you might want to open another window. I saw the hot air from the attorneys.
Right.
Post-Christmas sauna treat.
We don't have control over the temperature in the
I
building.
know, I mean,
unfortunately.
12 degrees does not make us intelligent enough to run our own heat and air.
Oh, no. And AI is artificially, should be AU, artificially unintelligent. Thank you. Be seated, please. All right, ladies and gentlemen, that completes the evidence. A fairly short trial, as we've indicated. So it is now the duty of the court to instruct you on the matters of law. Now, as I've indicated previously, the court and the jury have separate functions. You decide the disputed questions of fact. The court provides the instructions of law for which you're to use to do that. Now, it's your sworn duty to accept the instructions of the court and apply the law as it is given to you. You're not permitted to change the law or to apply your own conception of what you think the law should be. All criminal cases begin with the filing of an indictment. The indictment informs the defendant that he or she has been charged with an offense. The fact that it was filed may not be considered for any purpose. A plea of not guilty is a denial of the charge and puts in issue all the essential elements of the offense. The defendant is presumed innocent until his guilt is established beyond a reasonable doubt. The defendant must be acquitted unless the state produces evidence which convinces you beyond a reasonable doubt of every essential element of the offense that's charged in the indictment. A reasonable doubt is present when the jurors, after they have carefully considered and compared all the evidence, cannot say they are firmly convinced of the truth of the charge. It's a doubt based upon reason and common sense. Reasonable doubt is not mere possible doubt, because everything relating to human affairs or depending on moral evidence is open to some possible or imaginary doubt. Proof beyond a reasonable doubt is proof of such character that an ordinary person would be willing to rely and act upon it in the most important of the person's own affairs. Now, ladies and gentlemen, you're the sole judges of the facts, the credibility of the witnesses that were presented, and the weight of the evidence. To weigh the evidence, you must consider the credibility of the witness. You'll apply the test of truthfulness that you apply in your daily lives. These tests include the appearance of each witness upon the stand, their manner of testifying, the reasonableness of their testimony, the opportunity they had to see, hear, and know the things concerning which they testified, their accuracy of memory, their frankness, their lack of it, their intelligence, their interest and bias, if any, together with all of the facts and circumstances surrounding their testimony. Applying these tests, you'll assign to the testimony of each witness such weight as you deem proper. You're not required to believe the testimony of any witness simply because that witness was placed under oath. You may believe or disbelieve all or any part of the testimony. You will determine what testimony is worthy of belief and what testimony is not worthy of belief. The testimony of a defendant is to be weighed by the same rules that apply to other witnesses. Each witness was subject to direct examination by the party who called them and to cross-examination by the opposing party. During the cross-examination, counsel was able to inquire into some matters that did not relate directly to issues before the court. Such questions and answers were permitted for the purpose of helping you determine credibility and the weight to be given to the testimony for no other purpose. Now, evidence was received about the commission of a crime other than the offense for which the defendant is charged in this case. That evidence was received for a limited purpose. It was not received, and you may not consider it, to prove the character of the defendant in order to show that he acted in conformity or accordance with that character. If you find the evidence of other crime is true and the defendant committed it, you may consider that evidence only for the purpose of deciding whether he had a prior conviction as specified in the indictment, which is a municipal court case, or for determining the credibility of the defendant's testimony regarding the other offenses. Those other offenses may not be used for any other purpose. Now, you've also heard testimony that at the time that the letter in question was sent, the defendant was in jail. You're not to consider the fact that he was in jail for any purpose or to speculate as to why. You may have observed during the course of the trial that the defendant is in the custody of the sheriff's office. This is not an indication of his guilt or innocence. It simply means he was not able to post the bond the court required during the pendency of this action. And you may not consider the fact that he is in custody for any purpose. Now, ladies and gentlemen, evidence is all the evidence that was received from the witnesses and any exhibits that have been admitted into the trial, during the trial, and there were 5 of those. Now, evidence may be either direct or may be circumstantial or it may be both. Direct evidence is the testimony given by a witness who has seen or heard the facts to which they testify. It includes, of course, the exhibits that have been admitted into evidence during that trial. Circumstantial evidence is proof of facts or circumstances by direct evidence from which you may reasonably infer other related or connected facts which naturally and logically follow according to the common experience of mankind. To infer or to make an inference is to reach a reasonable conclusion or deduction of facts which you may but are not required to make from the other facts which you have found have been established by direct evidence. Whether an inference is made rests entirely with you. Now, when considering circumstantial evidence, you may not draw one inference from another inference, but you may draw more than one inference from the same facts or circumstances. So, in other words, you may not stack one inference upon another inference to reach a factual conclusion. So, what does that mean? Well, let's use the example, I think most of us growing up, and maybe those of you that have children at home, had a cookie jar. And you go into the kitchen and you see crumbs are scattered all over the kitchen by the cookie jar. You can deduct from that somebody's been in a cookie jar. Now, from that alone, you can't deduct two. You would need other facts. So you couldn't decide if you have 3 children, that, well, it was the oldest. That's not a fact. That would be stacking an inference. Now, if you have 3 children but only one's home, now that's another fact. Now you can make a deduction, it was that child. So that's what it means to not stack inferences upon one another. Now, if circumstances create inferences that are consistent with either acquittal or guilt, the defendant must be acquitted unless the inferences in favor of guilt rise to the level of proof beyond a reasonable doubt. In the absence of direct evidence of a person's guilt, circumstantial evidence by itself may justify a finding of guilty if the circumstances are entirely consistent with defendant's guilt, are wholly inconsistent with any reasonable theory that he is not guilty, and are so convincing as to exclude a reasonable doubt of guilt. Now, where the evidence is both direct and circumstantial, you must decide whether the combination of the two types of evidence overcomes presumption of innocence and convinces you beyond a reasonable doubt the defendant is guilty. Evidence does not include, as I indicated previously, the indictment, the opening statements that have been offered already, and the closing arguments of counsel that you're about to hear. The opening statements and closing arguments are simply designed to assist you, but they are not evidence. The evidence does not include any statements that may have been stricken by the court that you were told to disregard, and they are not evidence and must be treated as though you never heard them. You must not speculate why the court sustained an objection to any question or what the answer to that question may have been. You must not draw any inference or speculate on the truth of any suggestion that might have been included in a question that was asked that was not answered. And again, a number of exhibits were introduced and testimony relating to them has been introduced and admitted into evidence. You may consider whether those exhibits are the same objects in the same conditions they were originally, and you'll determine what weight, if any, each exhibit should receive in light of all the evidence. Now, the law under which the defendant is charged in count 1, and it's the only count of the indictment, is entitled Violating a Protection Order. And it is numbered Ohio Revised Code section 2919.27A1. And this law states in pertinent part as follows. No person shall recklessly violate the terms of a protection order issued pursuant to section 29.26 or 3113.31 of the Revised Code. So, ladies and gentlemen, in this case, the defendant is charged in count 1 with violating a protection order under that section. Before you can find the defendant guilty of violating a protection order, you must find beyond reasonable doubt that on or about September 27, 2023 in Highland County, Ohio, the defendant did recklessly violate the terms of a protection order issued pursuant to section 2919.26 or 31.31 of the Ohio Revised Code. Now, there are what's called essential elements of the offense that must be proven in order to return a guilty verdict. The essential elements of the crime of violating a protection order as charged in count 1 are as follows. That the defendant did 1, on or about September 27, 2023, 2, in Highland County, Ohio, 3, recklessly, 4, violate the terms of protection order issued pursuant to section 2919.26 or 3113.31 of the Ohio Revised Code. Now, it is not necessary that the state prove the offense was committed on the exact day as charged in the indictment. It's sufficient to prove the offense took place on a date reasonably near the date claimed. Now, before you can decide whether the state has proved beyond a reasonable doubt all of the essential elements of the offense with which the defendant is charged, you must first decide whether this is the correct county in which this trial should be held. The state must prove beyond a reasonable doubt that all or any part of the offense charged was committed as a continuing course in Highland County, Ohio. Now, The state of Ohio must prove beyond a reasonable doubt the defendant was served with a copy of the order, was shown the protection order, was informed by a law enforcement officer that a protection order had been issued prior to the alleged offense. Served means actual delivery of the protection order to the defendant. Protection order means an order issued by a court upon evidence presented for the safety of a protected person. Law enforcement officer means any of the following: a sheriff, deputy sheriff, constable, police officer of a township or joint police district, marshal, deputy marshal, municipal police officer, member of a police force employed by a metropolitan housing authority under Division D of Section 3735.31 of the revised code, or state highway patrol trooper. Now, a person acts recklessly when, with heedless indifference to the consequences, the person disregards a substantial and unjustifiable risk that the person's conduct is likely to cause a certain result or is likely to be of a certain nature. The person is reckless with regard to circumstances when, with heedless indifference to the consequences, the person disregards a substantial and unjustifiable risk that such circumstances are likely to exist. Recklessness requires more than mere negligence. A mere failure to perceive or avoid a risk because of a lack of due care does not constitute reckless conduct. One must recognize the risk of the conduct and proceed with heedless indifference to that risk. Substantial risk means a strong possibility as contrasted with a remote or significant possibility that a certain result may occur or certain circumstances may exist. Now, if you find that the state proved beyond a reasonable doubt all the essential elements of the offense of violating a protection order, your verdict must be guilty according to your findings. If you find that the state failed to prove beyond a reasonable doubt any one of the essential elements of the offense of violating a protection order, then your verdict must be not guilty according to your findings. Now, if and only if you have found the defendant guilty of the offense of violating a protection order as charged in count 1, you will then proceed to determine whether the defendant was or was not previously convicted of violating a protection order in Hillsborough Municipal Court, case number 19 CRB 242. If you find the defendant not guilty of the charge of violating a protection order, you will not make any additional finding on that issue. Now, that completes the instructions of law regarding the offense and what you need to make your decision. I will give you a copy of those once I make several. As you can see, I have made a few changes. I always cut and paste these from other cases, so unfortunately I've never been able to catch every single cut and paste error, and then sometimes things change. Since I prepared them, I need to add or delete, and I've done that. So once I get that done, you'll have a copy of these in the jury room with you so that you'll be able to refer to them if you have any questions and aren't able to remember what I said or perhaps disagree with what I said. Now, at this time, we're going to hear closing arguments from the attorneys. Closing arguments, as I previously stated, are not evidence. They are simply the arguments of each side as to what they think the evidence has or has not shown. The state has the burden of proof, and so under the law, the state has the right to offer opening statement, and then after the defense has made a statement, offer a rebuttal. And so at this time, I'll turn it over to the state of Ohio, Mrs. Collins.
Thank you. May it please the court, defense counsel, ladies and gentlemen of the jury. I first want to thank you for your time and attention to this matter. The United States is one of the few countries that uses a jury system to decide guilt in a case, and that only works because of people like yourselves who take your service seriously. And so for that, I want to thank you for your service today. Now, I told you this morning when we started that we would present evidence and testimony and the exhibits necessary to prove that this defendant, Allan Shoemaker, violated a protection order when he sent a letter from the jail to his ex-wife, Teresa Shoemaker. And at the end of the evidence, we have proven exactly that. Now, as the judge said, I have 2 opportunities to speak with you, so I'll keep the first short and to the point. My second chance will be a little longer. Now, the defendant and Teresa were officially divorced in 2019 after 36 years of marriage. But due to continued contact, Teresa asked for and was granted a protection order prohibiting the defendant from having any contact. She applied for that in June of 2023, and the protection order was granted. And the defendant was served with a copy of that protection order on July the 7th of 2023. Now, despite being aware of the order, having been served a copy of it, and knowing that he was allowed to have absolutely no contact including by mail. The defendant wrote a letter and sent it to Teresa Shoemaker. The envelope says Teresa Shoemaker. It doesn't say anything, this Grace Shoemaker business, until the bottom, under the address. It's to Teresa Shoemaker. It's very obvious when you look at the envelope that Grace Shoemaker was added as an afterthought. Her name is under everything else. The letter was mailed to Teresa's home address, and when she got the letter, she knew that it was a violation of the protection order, which specifically says no contact even by mail. It says that in the protection order, no contact even by mail. So she drove it straight to the sheriff's office and said, hey, he sent me this. He admitted today that he sent it. There's no question that he sent it. These are very simple. They're very straightforward facts. They're facts that have been admitted to. This defendant violated the terms and condition of a protection order. It truly is that simple. On September 24th, when he mailed the letter out to Teresa and when she received it on the 27th, that's the violation. It's a felony because he's previously been convicted of this crime. That elevates this crime to a felony. And as such, I'm asking you to reach the only verdict that makes any kind of sense in that case, and that's guilty. Thank you.
All right, on behalf of the defense, Ms. Witt.
Thank you, Your Honor. May it please the court and the prosecutor's office. I'd like to thank you all once again for your attentiveness this morning and your considerable thought that I know that you will give this very important matter. Beyond a reasonable doubt will most likely be your biggest challenge in your job here today in deciding Allan's innocence or guilt. And consequently, if the state proved beyond a reasonable doubt that Allan did not send the letter to his daughter as it was addressed on the envelope at her attention and as he testified here today. Additionally, nowhere in the letter is Teresa's name even mentioned. Some questions that were not answered today that leave reasonable doubt include, why was Grace's name on the letter? And, I'm sorry, I lost my place. Why was Grace's name on the letter? And where is the cover letter that Allan testified to as well? That stated that it was to
Objection
Grace's
to what it
attention.
stated.
Okay. Well, I'm sorry, what?
I said objection as to what it stated.
Well, I'm
It
going to
doesn't
overrule it's in
As
evidence.
Allan testified,
It's our-
it stated. We do not believe that the state proved beyond a reasonable doubt that Allan did not send the letter to his daughter and ask you to determine the same thing and that Allan is not guilty. Thank you very much.
All right, on behalf of the state, rebuttal.
Now, during this trial, there may have been some things that were mentioned that weren't developed, and those may have left questions in your mind. But be mindful of the judge's instructions, and even what we talked about in jury voir dire. The only thing that you can consider when deciding guilt or innocence is the testimony that you heard from that witness chair and the exhibits that were admitted into evidence. Nothing that maybe were setting questions as evidence. Only the answers from the chair is the evidence that you can consider, and only the exhibits that were admitted into evidence. So, for example, this cover page that is alleged to exist, it's not in evidence. There's no, Teresa said, this is all I got. I took the entire thing to the sheriff's office, and this is it. And this is what's in evidence. And one of your main jobs as the jury is to weigh the credibility of the witnesses, and to do it, you use the same test for truthfulness that you use in your everyday lives. You look at a person's appearance, their appearance on the stand, their manner of testifying, the reasonableness of their testimony, their opportunity to see, hear, and know the things that they are testifying about. Look at the accuracy of their memory, their frankness, their lack of frankness, their intelligence, and very important, you look at their interest and bias, and you take that with all the facts and circumstances surrounding the testimony, and you make the decision about whom to believe. So in applying this to the three witnesses that you heard from the state, Deputy Ronnie Hughes and Lieutenant Keith Brown, both of the sheriff's office, are what I call fact witnesses. In other words, they collect evidence, they provide that evidence to you in an effort to explain exactly what happened, what has taken place. They have no interest and bias in the case. Teresa Shoemaker is the victim in this matter. She again has no interest or bias in the case. and has just presented the facts as she knows them. None of the witnesses for the state have anything to gain by testifying today. They simply relayed the facts and evidence to you so that you would have a complete understanding of the case. Now, the only person with any reason or any interest in this case, any bias in this case, is the defendant. He's the one that wants you to believe that he sent this letter to Grace, even though there's no question there is no Grace. Their daughter's name is Courtney. He admitted on the stand when I questioned him, does Courtney know this nickname of Grace? No. He's the only one that knows this nickname of Grace because he's made it up. He's made it up so that he could send Teresa mail and try not to be held responsible for what he sent to her by putting a fake person's name on it. Teresa told you that other times when he has sent mail to the kids via her address, he has put Courtney on the mail and she's provided it to him. The 3 kids, Seth, Ethan, Courtney. I said, has he sent mail to your house for them before? Yes. What names does he put on them? Puts Courtney's name on it because that's her name. Grace is not a nickname. Grace is this pretend person that Mr. Shoemaker has made up so that he is trying not to be held responsible for what he knows he's done, which is violate a protection order. There is no Grace Shoemaker. He admitted that only he knew about the nickname. He's making this up, but really, it makes no difference. The letter was addressed to Teresa, right here. Teresa Shoemaker. He sent it to her. That's a violation of the protection order right there. Even if she had not opened it and just marched it up to the sheriff's office without even looking at it, violation of a protection order. He mailed a letter to her. The protection order says no contact, even by mail. This defendant knows that this is a violation. He's been convicted of it 3 other times. He's trying to come up with ways just to get around the protection order. Now, the state must prove each and every element of the crime by proof beyond a reasonable doubt. And the elements of the case are followed and are outlined for you in the jury instructions on page 5. Now, on or about September 27th of 23 and in Highland County, Ohio, the defendant recklessly violated a protection order or consent agreement that was issued pursuant to 2919.26 or 3113.31. Those 2 numbers are sections in the Ohio Revised Code. And I'm going to go through each element and point out the specific evidence and testimony that was presented and proved each element beyond a reasonable doubt. First, the date. The defendant mailed the letter on September 24th per the jail log, which is State's Exhibit 3. The very first line of the jail log, Allan Shoemaker to Teresa Shoemaker, date 9/24/23. She received it on 9/27. That was her testimony, and that's the day that she brought it up to the sheriff's office on the 28th per the testimony of Deputy Hughes. The state has proven the date, on or about September 27th. Next, Highland County. The testimony was the defendant was at the Highland County Jail when he mailed the letter, and the testimony was that Teresa's address is in Highland County, so this took place in Highland County. The state has proven Highland County by proof beyond a reasonable doubt. Now, the defendant acted recklessly. He knew that sending the letter to Teresa was a violation of the protection order, but he just did it anyway, recklessly did it anyway. As soon as he wrote, addressed, and mailed the letter, even putting Ray Shoemaker's name on that, reckless, he knew. Finally, the defendant was violating the terms of protection order that was issued pursuant to 3113.31 of the Revised Code. And this is in your jury instructions, but it's not difficult. You don't have to memorize these numbers or anything like that because State's Exhibit 2 says CPO, full hearing, RC 3113.31, right here. This is a CPO issued pursuant to that Ohio Revised Code section. And that's necessary, it's in your jury instructions, but right here it is. We've proven that. It was a CPO issued under that section. It's right on the CPO. The state must prove the defendant was served by a law enforcement officer with a copy of the protection order. He admitted that he was served with a copy of the protection order. He admitted that he knew about it, but even had he not, the state has a copy of the return of service. Right here, State's Exhibit 4. On the bottom, Madison County Sheriff served Allan Shoemaker July 7, 2023 by Deputy Brian Bingaman of John Sweeney's the sheriff, right here on the bottom. But he admitted it to you anyway, so no question that he was served with a copy of it. The state has proven each element of this crime beyond a reasonable doubt. And additionally, the state has proven beyond a reasonable doubt that he's previously been convicted of this crime. State's Exhibit 5, the prior conviction out of Hillsborough Municipal Court, which he admitted he had been convicted of it before, but you'll have the exhibit back in the court, back in the jury room with you. It is a violation. This is a finding of guilt for 29-19-17-27, 29-19-27, violating a protection order. And again, he admitted it to you. He has previously been convicted of this crime. It's important that you note that because on your verdict form, there's a section underneath where it says additional findings. We further find the defendant was or was not previously convicted of the crime. He was previously convicted of that. You have to circle was in that finding if you find that he's guilty. Now, you may be thinking, and Ms. Witt tried to bring this up a little bit, well, it's just a letter, what's the harm? Well, it doesn't matter that there's no threat in the letter. It doesn't matter what the letter says. The harm is he violated the law. The harm is that she asked for an order of protection. She has the right to live the rest of her life peacefully. He's not allowing that. Look at page 6 of 7, which was testified to, State's Exhibit 2. Allan Shoemaker shall have absolutely no contact, underlined, no contact with Teresa Shoemaker, even by mail. This has been a problem. They wrote this out because it's been an issue. The court wanted to make it perfectly clear, you're not going to do this anymore. Stop. That's the harm. The fact that she has to go to her mailbox and see things from him, that's the harm. It doesn't matter what's in the letter. That's the harm. He's violating the law. The letter the defendant mailed is a direct violation of this order, and as such, a direct violation of the law, and that is the harm. Now, the state must prove each and every element of the crimes charged beyond a reasonable doubt. Reasonable doubt is doubt based on reason and common sense, and you can equate this to your own lives and decisions that you have made in your lives. For example, buying a car. You shop around and you collect evidence, the same as sitting on a jury and listening to the evidence. You want a red SUV and you find one, the odometer says 50,000 miles, your payments will be $250 a month, so it fits in your budget. And it's everything that you want in a car. All the evidence points to you buying that car, and of course you buy it. Now, there is some remote possible doubt that this isn't the perfect SUV for you, but reasonable doubt, doubt based on reason and common sense, has been overcome, and of course you buy the vehicle. It's not your job to look for reasonable doubt. If reasonable doubt had existed in this case, it would have presented itself. It just simply doesn't exist. There is no doubt in this case. He sent the letter. He admitted that he sent it. He knew he was under a protection order, and he addressed the letter to Teresa. It's a violation, period. That's it. Ladies and gentlemen, this case is not difficult. The facts are not complicated. The testimony is straightforward. The exhibits prove each element of the crime. This defendant was served a copy of the protection order, and despite that, he mailed a letter to Teresa. It's a direct violation of the protection order, and he's previously been convicted of this. Don't try to make the case difficult. It really is that simple. And simply put, the only verdict that makes sense in this case is guilty. And I'm asking you now to go find him guilty. Thank you.
Okay, thank you. All right, ladies and gentlemen, you've heard the closing arguments of counsel. Again, I instruct you, they are not evidence, but they're simply the opinions and arguments of the attorneys of what the evidence has or has not shown. Now, I have some additional instructions to give you regarding the deliberations and completion of the verdict form, but I think what we're going to do is take an early lunch, because I know a lot of you were here by 7:30 this morning and had an early rise that you may not be used to. And I do have to make some corrections. So I'm going to adjourn for lunch and have you come back at 12:30. During that time, then I'll make those final corrections. That time I'll give you the final instructions that govern your deliberations. while you're deliberating, you're not permitted to have any cell phones or any other electronic devices in the jury room because you have to have only communication through the bailiff. And so if you bring your phones with you, they'll be collected back on the back window sill there, and the bailiff will keep them in bags and so forth, and then give them back to you after the deliberations. If you want to leave them somewhere else and not bring them to the courtroom, that's up to you. During the deliberations, remember all the instructions I've given you, they still are governing you. You're not to discuss the matter in any way with anyone, even among yourselves, because you haven't had the final instructions yet from the court. You're not to research it on the internet, not to look up anything about it. Don't post anything about it. Don't permit anyone to speak to you about it in any way. Don't try to obtain any other information about the case outside of what's been presented in the court in the trial. So it's now 11:22, almost 11:23. So be back in the jury room no later than 12:30. Thank you.
Please rise.
Thank you. Be seated, please. All right, we're back on record. State versus Shoemaker. The jury is returned. And now it's time for me to give you the instructions on deliberations and how to return your verdict once you've reached it. You must be uninfluenced by any consideration of any sympathy or prejudice. It's your duty to carefully weigh all the evidence, decide all the disputed questions of fact, to apply the instructions of the court to your findings, and render your verdict accordingly. Now, in fulfilling your duties, your efforts are to arrive at a just verdict. Consider all of the evidence and use your common sense to make your findings with intelligence and impartiality, without any bias, sympathy, or prejudice, so that the state defendant will feel that their case was fairly and impartially tried. Now, if during the course of the trial the court said or done anything that you consider an indication of my view of the facts or the case in general, you're instructed to disregard it, because under the law the court has no right in any way to invade and doesn't desire to invade the province of the jury by indicating a preference between the parties. The reason I include that instruction, there's a standard instruction there, but also I give an example that I had about 30 years ago when I was still practicing law, and I had a client come in, had just been on a jury that I had tried. Case that I tried. And so I asked that client, I said, well, what was your experience? And we were talking about that. And I said, well, so how did it come that you made a decision? That juror said to me, well, we kind of watched what the judge did, and from what he said, we thought that's what the verdict ought to be. And I didn't say anything to them, but since then as a judge, I've always said to people, my rulings don't mean anything other than the law, applying the law. It's not to express any kind of a preference, so don't take it that I have. Now, upon commencing your deliberations, your initial conduct is of great importance. It's not wise to immediately express a determination or to insist upon a certain verdict, because if your sense of pride is aroused, you may hesitate to change position even if you decide later that you may be or are wrong. Consult with one another, considering each other's views, and deliberate with the objective of reaching an agreement if you can do so without disturbing your individual judgments. You must each decide the case for yourself, and you should do so only after a discussion and consideration of the case with your fellow jurors. Do not hesitate to change an opinion if you find that it's wrong. However, you should not surrender an honest conviction in order to be congenial or to render a verdict solely because of the opinions of the other jurors. Now, you may not discuss or consider the subject of punishment. In the event you find the defendant guilty, the defendant to determine the punishment is placed by law upon the court. Now, when you go to the jury room, your first function will be to select one of your number as a foreperson. That person you select will preside over your deliberations, but does not have any greater power, nor does that person's vote have any greater importance than anyone else's. Foreperson simply serves the purpose of helping you to conduct your deliberations in an orderly manner, and to give each juror an opportunity to express your opinion. One additional duty of the foreperson is to see that the verdict form and exhibits and copies of the instructions are returned after you've reached your verdict. Now, again, I'll put in your possession the exhibits which are up here on the bench, the verdict form, it says forms, which there's only one, and the foreperson will retain possession of these records, including the verdict form, return them to the courtroom after you've completed your deliberations. Now, until your verdict is announced in open court, you're not to disclose to anyone else the status of your deliberations or the nature of any verdict or verdicts that you would have. Now, this being a criminal case, before it can be said that you have reached a verdict, it's necessary for all 12 of you, and I'll repeat that, all 12 of you, to agree upon a verdict. Now, you will have in the jury room a verdict form right here. And that verdict form reads, "We, the jury, having been duly impaneled and sworn, find the defendant, Allan W. Shoemaker." Then there's a blank, and you may be able to see it from there. And underneath that, there are a couple of asterisks that say, insert guilty or not guilty. That's where you will insert your verdict. And then it goes on to say about the charge, violating protection order, consent agreement as he stands charged in count 1 of the indictment. And so if your verdict is guilty, you write guilty. If it's not guilty, you write not guilty. Now, in the event that you find the defendant guilty, and only if you find him guilty, are you then to consider the additional finding. And that language reads, "We further find that the defendant was or was not previously convicted of or previously has been convicted of a violating a protection order consent agreement as alleged in count 1. And I see that my printer ink was going out when I printed this. I had to change it during the break, so I'll have to print this out because it's, some of it's obscure. I was having trouble reading it, but I'll fix that and send that back to you right away. And so you will circle or strike out the findings so it shows whether you're saying that he was or was not previously convicted. But again, if you find him not guilty, then you don't complete that part of the verdict form. Now, once you've reached an agreement, a verdict I should say, you will then each sign your name in ink on the lines provided. Because all 12 of you, and again I'll repeat, all 12 of you have to agree on that verdict, or you don't have a verdict. Once you deliberate, you'll be under the charge of the bailiffs. One will be stationed outside the door to the jury room and ensure that your deliberations are not disturbed. However, they cannot talk with you about the case, can't answer any questions. If you have any questions or other needs, write it down, knock on the door, give it to the bailiff, he'll provide it to me, and then after I've reviewed them with the attorneys, I'll respond in writing. Can't promise you I can give you what you request, but I can promise you that it will be fully and carefully considered. And so what's an example of that? Well, sometimes someone will say, well, we'd like to know whether the officer arrived at 6 o'clock or 6:30. Well, we can't, if it's not in the evidence, I can't answer that question. There was no testimony about it in the record, theoretically, or I mean hypothetically, then I couldn't give you that. So, you know, if you ask me for something that was not admitted, I'll have to say you have to decide a case basically on the evidence that was presented only. If it's a question about the law, I'll probably respond in writing. I will respond in writing and probably will point out on the, which page of the jury instructions you'll have with you that apply to that. But don't hesitate to ask a question if you think you need some guidance. Now, I want to thank all of you for your patience, cooperation. You've been very attentive, and clearly in this case, your time wasn't wasted. The case was presented very expeditiously, although I think completely, and each side had the opportunity to do that. Now, as for the alternates, at this time, I'm going to excuse you, but I need to give you some additional instructions. We'll need to have your phone number so that in the event that something should happen to one of the first 12 jurors, we can call you. So we need to either remain around the courthouse or within 20, 25 minutes in the event that that happens. I can tell you I've had it happen twice in 15 years. I don't, so it doesn't happen very often, but occasionally it does. And if that occurs, then you'd have to come in. And then we will notify you, the bailiff will, once there's a verdict reached, so that you're aware of that. Now, until you're notified that there is a verdict, you're, again, still under the instructions of the court. You're not permitted to discuss the matter in any way, not to talk to any of the parties or the participants in the case, not to read or hear or view or listen to anything about it in radio, TV, internet, or anything of that nature. And so you'll still be under those same obligations, and you're not to form any opinions about it until you've been told that the verdict has been returned. All right, is there anything further in counsel?
One thing with the instructions, Your Honor, if we may approach.
All right. Exhibits will be with you. I'll make a correction to the verdict form, and I have to make one typo correction to the instruction, and then you'll have those delivered to you. Thank you.
Please rise.
Thank you. Be seated, please. All right, we're back on record on State versus Shoemaker, and my understanding from the bailiff that the jury has reached a verdict. Is that correct?
Your Honor.
All right, bring the jury in, please. All right, jury has returned to the courtroom, and looks like Mr. Hyatt, you're the foreperson.
Yes.
Has the jury reached your verdicts?
We did.
If you would present that to the clerk, please. Would you read the verdict, Mr. Hodson?
In the Court of Common Pleas, Highland County, Ohio, State of Ohio versus Allan W. Shoemaker. Case number 23CR 207. Verdict, count 1, violating a protection order or consent agreement. Revised Code 2919.27A2. We, the jury, having been duly impaneled and sworn, find the defendant, Allan W. Shoemaker, guilty of violating a protection order or consent agreement as he stands charged in count 1 of the indictment. We further find that the defendant was previously convicted of violating a protection order or consent agreement as alleged in count 1 of the indictment.
Thank you, Mr. Hodson. All right, the court will note that the verdict is signed by all 12 jurors, and I'll ask if all 12 of you agree and that it is a verdict of each and every one of you. All right, they've all indicated an affirmative. Any request for a polling of the jury?
Nay.
All right. All right. Then the court will accept the verdict of the jury and enter a finding of guilty. All right, ladies and gentlemen, that completes your service for this case. Again, I want to thank you for your service, fulfilling the duties of citizenship, as have many before you and hopefully many after you will. This will excuse you from any further service this quarter. So if by chance we don't get that into the system and you get another notice, just call and remind whoever answers that you were on this jury and you'll be excused. Then you'll be excused for another 1 year after that. So with that, you can go ahead and get your phones, go down to the clerk's office, and Mr. Hodson will have your pay vouchers and any work excuses you may need. Again, thank you for your service. Counsel, everybody remain. I need to go get them. I'll be back in. All right, the jury has returned a verdict of guilty of violating a protection order consent agreement, 5th degree felony. This matter is not subject to the TCAP due to the defendant's previous felony conviction for offense of violence, and therefore the court will proceed with sentencing forthwith. Now, the court will note that Ms. Shoemaker, the victim of the offense, is present in the courtroom, and I'll hear from the state at this time regarding anything you'd like to say regarding sentencing.
Thank you, Your Honor. First, Ms. Shoemaker does not wish to address the court today. She has been advised that she has the right to do so. We would ask the court to impose a term of incarceration of 11 months. We would note that this defendant is under a term of post-release control. That was filed, actually it was filed in another case and then added to this case on November 9th of 2023. By my calculations, the time remaining on PRC would be 12 months because it's the greater of 1 year or whatever time is left. So I believe that would be 12 months. I would just note that essentially, and the court has heard the testimony, reviewed the exhibits, basically Mr. Shoemaker just thinks that he can just do whatever he wants for as long as he wants. He just continues to violate the same law over and over and over and over again, and then make excuses for it. Today, trying to say that he uses a nickname for his daughter as Grace, but even if that were the case, he cannot send mail to Teresa's house addressed to Teresa or not addressed. He can't send mail. It's been a problem. It's an ongoing problem. He needs to learn from this. And as such, we would ask the court to sentence this defendant to a term of incarceration. Thank you.
Right, does Ms. Shoemaker wish to be heard? No, all right. On behalf of the defendant?
Yes, Your Honor, we ask the court for the minimum sentence that the court can provide, given that Mr. Shoemaker is looking at a year of PRC time, and it is a lower level felony, so just ask for the minimum sentence that the court could impose.
All right, Mr. Shoemaker, is there anything you would like to say?
I don't think so, no.
It's your chance to say something if you want to.
I know, I just was trying to get a hold of my kids. That's all.
I'm sorry,
I've
I
been
can't
trying-
understand you.
That's what I've been trying to do. Excuse me?
You're going to have to speak up. I'm having trouble hearing you.
Yeah, so I have that problem too. I've just been trying to get a hold of my kids. I mean, you know, I've tried to call and nobody answers. And the only address I've got is that one. And I didn't even have that one right. So I don't. That's all I've got, I guess.
Well, Mr. Shoemaker, it sounds like a good excuse, but, yeah, it's not. And, you know, you've been engaging in this persistent pattern of conduct for years now, and even while you're in prison. And the fact that you don't have another address for your children, assuming that's true, it doesn't mean you can send mail to them, care of her, because the order says you're not to communicate with her. It doesn't say, nor send mail, contact. It says no contact. It doesn't say no contact except sending mail to my children or to your children, care of her, or contribution to the church or something else. No contact means no. There's a famous country song by Lori Morgan. It's what part of no don't you understand? The record in this case shows you don't understand a damn bit of it. You just refuse to take no for an answer. You are putting yourself above the law. And I know you've made comments before, you know, but you know it's time to stop. Because every time you send some sort of a letter or communication to her, you're violating the protection order. You know, what you just said isn't an excuse. No means no. No letters of any sort. If you don't have an address for your children, then try to figure out another way to look at it. There's public records, all kinds of stuff available on the internet, and I know prisoners have access to internet. You can check the voting records. You can check the real estate records. You know, you can just run something on the internet and get an address pretty quickly. It's not hard. So that excuse is just crap. It's nothing but an excuse. Now, the woman is divorced from you, your marriage is over, whether you like it or not, and you have to just, if you don't want to accept the fact that, for religious purposes, that's your right, but it doesn't give you the right to violate the law. And as long as you continue to do so, you're going to continue to be back in front of the judge, and you're going to continue to be sentenced to prison when you get convicted. Because some of these offenses occurred, while you were on the run in earlier cases, and then while you were in prison, and now while you're in jail. So it is the judgment of the order of the court that you be and are hereby sentenced to a term of 12 months. And the court specifically finds that this is the worst case form of the offense. I don't know what could be worse, because when I look at your previous record, this would be, I believe, your third conviction for violating, actually fourth. No, that's a pending one. Yeah, third conviction for violating protection order, plus a menacing by stalking. Actually fourth, because it was a menacing by stalking and violating a protection order in 2019. So it is your fourth time you've committed this violation. So 12 months is the sentence. And it's also the order of the court that because you committed this offense while you were under post-release control from your previous conviction, and according to the notification filed on November 8th, I believe it was in this case, or maybe it was the 9th, I was just looking at it here a second ago, that had that your time at that time on November the 8th was 256 days. So under the law, when you're convicted of an offense while under post-release control, you're to receive the greater of 12 months for the time left, whichever, and in this case, since there's less than 1 year left, 1 year is the greater. So it's ordered you be sentenced to an additional 1 year for committing this offense while under post-release control in this case, and that sentence is ordered to run consecutively to the sentence in the new case. Now, the sheriff has submitted a statement that you were incarcerated from September the 12th, but that was on a different case. The indictment in this case was returned on 11/9, and so 11/7. So the court will give you credit on this sentence from November the 7th, and that, according to my calculations, is 62 days. Now, upon completion of this sentence, Mr. Shoemaker, the adult parole authority may, again, put you on post-release control. My hunch is they probably will because of your past, but it's up to them whether they do or not. The court doesn't have any say in it. And if they do, you'll be supervised under the terms they say for a period of up to 2 years. And if during that period of time they determine that you have failed to comply, they can return you to prison to make you serve an additional period of up to half of the prison term for one or more violations. But again, if you're convicted of an offense, felony offense, as you have been here, while under post-release control, and again, in addition, whatever sentence could be imposed for that conviction, that sentence would also subject you to being sentenced to an additional 1 year, in this case, for violating the law, committing a felony while under PRC in this case, and again, by law, that has to be served consecutively to the sentence in the new case. Now, you're also ordered to pay the court costs, and if you fail to do that, the clerk can collect that through various means, including levying on bank accounts, wages, earnings, or other assets you may have. If that doesn't collect it, then upon completion of the sentence, not while you're in prison, but once you get out, the court could permit you to do community service in this county and give you credit for each hour you work in an hourly rate set by the court. Each hour you work will reduce your judgment by that amount until paid in full. Now, you have the right to file an appeal from the verdict and the sentence. And that appeal must be filed within 30 days. It requires the filing of a written notice of appeal with the clerk of the court here, as well as the clerk of court for the Court of Appeals, which is the same person, Mr. Hudson. You are entitled to have all the papers and transcript of the proceedings provided for purposes of prosecuting that appeal. If you do not have the funds to pay for those, the court will provide those for you at no cost. You also have a right to file an appeal. You also have a right to have an attorney to prosecute that appeal. And if you do not have the funds to hire one, the court will appoint one for you. And that request will have to be made forthwith. Now, I would ask trial counsel if, to consult with Mr. Shoemaker if he does wish to file an appeal, to go ahead and file that notice of appeal and then determine whether or not you're going, if you are not going to represent him on the appeal, which nowadays that's not very common, but in some cases it does. But if you wish to, then just file your notice of appeal. If you're only doing it for purpose of protecting the record, just indicate it's a limited appearance and that the defendant wishes to have counsel, and I'll appoint counsel for his appeal. All right, is there anything further from counsel?
Judge, I just have a quick question. In the PRC section, the form says minus any time the defendant has spent. That comes out, correct? Because it's just 12 months.
Yes.
Okay.
Yeah, just 12 months, because it's the time left's less than 365. Yes. All right, anything further?
Thank you, Your Honor.
All right, you're remanded to custody.
Please rise.
Much, guys.